Welcome to Civics and Coffee. My name is Alicia, and I am a self-professed history nerd. Each week, I'm going to chat about a topic on U.S. history and give you both the highlights and occasionally break down some of the complexities in history and share stories you may not remember learning in high school, all in the time it takes to enjoy a cup of coffee.
Hey everyone, welcome back. In my journey to dissect the various aspects of Reconstruction, I find that I keep coming back to historian Eric Foner's idea that this period in history constituted a second founding for the nation, specifically the passage of the 13th, 14th, and 15th Amendments. And while I have covered these amendments on the show, I felt that there was more to discuss than my brief overviews could provide. Luckily, I connected with a scholar who had just the right background to have a larger dialogue. Thus, a few weeks ago, I sat down with Dr. Matthew Brogdon to discuss the legal history and legacy of Reconstruction. As you will hear in the episode, Dr. Brogdon is an expert in American Constitutionalism and someone whom I felt was perfect to explore the larger themes of Reconstruction. We recorded our interview over Zoom, so I am inserting my standard sound quality warning here. I hope you all enjoy the conversation. Hey everyone, welcome back. Joining me today is Dr. Matthew Brogdon. He is a political scientist who specializes in American constitutionalism and the evolution of the federal judiciary. He is also the co-host of This Constitution, a podcast that explores the most pressing questions of our current moment by looking to the past. Given Matthew's training and expertise, I thought he would be a perfect guest to come on and chat about the constitutional side of the Reconstruction era. Welcome, Matthew.
Thank you for having me, Alicia. I'm really excited to be here.
Thank you so much for coming on. I can't wait to dive in. So we'll start with the first question that I have for you, which is some historians refer to the Reconstruction era as a second founding for the United States, citing both the growth of the federal government and the passage of the 13th, 14th, and 15th Amendments to the Constitution as their evidence. As someone trained in political science, how would you classify this period?
I think second founding is a helpful way to think about this. Some other folks might want to put more emphasis on the idea of the Reconstruction Amendments as an elaboration of the founding or an extension of it, maybe even a development, which I'll accept, sort of suggest kind of growing into something that started with the framing of the Constitution in 1787 and is being developed or completed. So second founding, the only danger there, I think, is suggesting that it's some sort of a start from scratch, which it's not. It is certainly in some ways a bit of a reset, but depending on the way you read the sort of principles of the Constitution as it was originally created by the framers, you could look at it as a fulfillment or growth, which is the way that I kind of prefer to think of it, though that's loading the dice a little bit. I mean, it's making a bit of a judgment about what the principles are driving our constitutional order at the start.
Well, and, some of these amendments had such a profound impact to the Constitution. So can you kind of walk us through the passage of the 13th Amendment specifically and how that kind of fundamentally altered the Constitution?
Yeah, absolutely. The 13th Amendment abolishes slavery. And really, to understand the 13th Amendment, you kind of have to understand the saga of the relationship of slavery and the Constitution. And we could march that all the way back to things like the Northwest Ordinance in 1787 and all the politics of fugitive slaves and westward expansion. But right in back of the 13th Amendment is, of course, Lincoln's Emancipation Proclamation. And I think it's kind of helpful to start the story of the 13th Amendment there, if we're just looking at Reconstruction, because it was a bit of a tipping point. Lincoln's Emancipation Proclamation announces in September of 1862, right in the thick of the Civil War, that if states remain in rebellion, that in those states that are in rebellion on January 1st, 1863, he will declare people held in slavery in those states to be thenceforward and forever free. So this is that language of the Emancipation Proclamation, that those individuals will not just be free as a matter of a war measure, but thenceforward and forever free, is language that Lincoln chooses quite deliberately to create a kind of commitment on the part of the federal government. So I think once the Emancipation Proclamation comes along, it doesn't secure the freedom of every person held in slavery in the United States. Far from it. There were several states that were actually remained in the Union, but had slaves. Delaware, Kentucky, and Maryland were the most important of those. I think Louisiana was largely under the control of the federal government at this point, Missouri. So some very important slave states that would not be touched by the Emancipation Proclamation. But from Lincoln's standpoint, once the federal government had taken that first step of freeing these individuals and declaring them to be, it set us on the road to an amendment that would accomplish that aim of abolition fully. So it really is, the Emancipation Proclamation is a fulcrum, you think of a teeter-totter, and it really is the point at which I think the teeter-totter tips the other way. And it's clear that the Civil War is going to result in a significant change to the system of enslavement in the United States.
Yeah, and one of the things that we talked about in kind of prior conversations and in preparing for this discussion is how kind of the 13th Amendment and the 14th Amendment go hand in hand. And so can you explore a little bit on how you see the 13th and 14th Amendments working together to kind of redefine this concept of citizenship and civil rights in post-Civil War America?
That's right. We think of the 13th Amendment as in tandem with the 14th, as abolishing slavery. The 13th says neither slavery nor involuntary servitude shall exist in the United States or any place subject to its jurisdiction. Gives Congress power in Section 2 to enforce that prohibition on slavery. And then we think of the 14th Amendment as an elaboration on that is extending certain essential liberties to all of those individuals who had up to that point been enslaved and now are citizens of the United States. And that is a helpful way to think about it. On the other hand, the 13th Amendment created some problems that the 14th Amendment had to solve too. So when the 13th Amendment abolishes slavery, you have a couple of issues that arise. One is, what does the abolition of slavery mean? Does it mean simply getting rid of the economic system or contractual, I guess we should say non-contractual arrangement whereby people are held in involuntary servitude? Or does it extend further than that and also require a sort of revolution in the social system? What comes to be called, I think really helpfully by Supreme Court Justice John Marshall Harlan later, as the system of racial caste. Mm-hmm. So does it just attack the arrangement of forcing a person to work for you without pay, or does it go further and require revision of social caste, a kind of rooting out of that hierarchical system that creates, in our case, race-based slavery? There are other bases for slavery, by the way. It doesn't have to be based on race, but in the United States, it was a system of racial caste that supported the system of chattel slavery. So that's one sort of question. I think the 14th Amendment has to answer that question. To what extent is the federal government going to reach in and revise the system of laws in the states to reflect not just the erasure of slavery, but the establishment of citizen equality without respect to race? So that's pretty huge. There are a couple of other problems, too, that we just mentioned, and then we can tackle one or the other of these. Other problem is that the 13th Amendment, by abolishing slavery, actually changes representation in Congress in a really significant way. The 3/5 compromise in the original Constitution said that people who were not free could not count fully towards your representation in Congress as a state, particularly in the House of Representatives. That also played into the presidential election, too, because weight in the Electoral College was based on congressional representation. So when you abolish slavery, there's no longer anyone in the category of unfree persons. Okay. And that means that South Carolina, for example, half of whose population had been enslaved up until 1865, is now all free. So, whereas South Carolina could only count 3/5 of those people who were held in enslavement before 1865 toward their congressional representation, now they get to count 5/5. Everybody's going to count 5/5. Now, that sounds good, right? We're going to recognize the equality of individuals. But the practical effect of that is to increase the weight of representation in Congress for states that had large slave populations. So the South is going to get more seats in Congress because slavery was abolished. So this is also a problem that the people framing the 14th Amendment have to solve. And that's going to show up in a really vivid way. In December of 1865, the 13th Amendment was sort of completing ratification at that point. The last state to ratify is going to be Georgia. And a bunch of southern states, many of them who had been in rebellion, show up at Congress. That is, they had elected members of Congress under these provisional constitutional governments that President Andrew Johnson, who succeeds after Lincoln's assassination, had authorized states to create these new constitutions. And he says, ratify the 13th Amendment, write a new state constitution, and you're back in the fold, right? You're back in the family. You can have a seat at the table. And so a bunch of members of Congress from the South show up at Congress in December of 1865 wanting a seat. And Congress refuses to seat these folks. So the 11 states that had been part of the Confederacy, the House and Senate sort of lock the door and say, you don't have seats in Congress. We don't regard you as being full and equal states until some kind of Reconstruction has intervened. So that is the Congress that is going to write the Civil Rights Act and the 14th Amendment, with 11 southern states who had been in rebellion sort of knocking at the door and wanting back in, and all of those states having even more representation than they had before. So that's the situation we're standing in when we get to the 14th Amendment. And so the 14th Amendment has to kind of solve all of those problems. Yeah. And it does make it a fairly complex piece of constitutional language.
Yeah, you refer to the 14th Amendment as kind of an attempt to solve several problems. And other scholars have kind of referred to the 14th Amendment as kind of designed to give teeth to the 13th Amendment. Is that a sentiment you agree with?
I think that's right. Well, let's put it this way. The folks who want to put teeth in the 13th Amendment win by getting the 14th Amendment. Now, there were lots of folks in Congress who thought, we abolished slavery, let's go back to business as usual. That is, there's a fair number of unionist moderates who are glad to see an end to the Civil War. They want to follow through on the basic promise that the Emancipation Proclamation made and abolish slavery, so that we get rid of that. They want many of the Republican policies that had been in place before the Civil War, things like preventing the extension of slavery or racial caste policies to new states and things. But they're not particularly interested in a wholesale reconstruction of Southern society. So we got rid of slavery. There's no need to go trying to root racial caste out of our society. So those sort of moderate unionists, one of whom is in the White House in the form of Andrew Johnson, they want to go back to the status quo ante. Let's get everybody back around the table as quickly as possible and get back to the business of pursuing American prosperity and union. Many other members of Congress want something more extensive, a more extensive reconstruction of Southern society. And those folks win whenever they get the 14th Amendment. The open question is, would they have won or gotten those things had it not been for the other problems? That is, that one of the things that made the 14th Amendment kind of imperative were the whole set of problems that they faced, not just equality for newly freed slaves, but the whole political issue of what do we do about Southern states that are now going to have increased influence in Congress, and so on. What do we do about the question of citizenship, for example? Part of the problem here is the Constitution prior to the 14th Amendment really says nothing about who's a citizen, or even it doesn't say much about who decides who's a citizen. Congress has a power under the original Constitution to make uniform rules on naturalization, the process of becoming a citizen, but there actually are no constitutional rules about birthright citizenship, for example, even though that was a tradition. We inherited a common law tradition where people born in the United States were presumed to be citizens, and people who moved here would go through a process of naturalization. But there was nothing in the Constitution that told us how that would work. So those ambiguities in the original Constitution, those sort of lacuna or gaps, really created a situation where the advocates of doing more than just abolishing slavery really got the upper hand, because they could say, we really have to solve these problems. It'd be great, I guess, we could talk about what the 14th Amendment does in terms of its actual language. So if people are familiar with the text of the 14th Amendment, they're probably familiar with Section 1 of it. And especially right now, the very first words of the 14th Amendment tell us that all persons born or naturalized in the United States are citizens of the United States and the state wherein they reside. I actually left out a phrase there. I should have said, and subject to the jurisdiction thereof, state. But that's the provision that stands at the front of the 14th Amendment and solved that citizenship problem for us. That provision had actually already been put into federal law earlier in the 39th Congress in the form of the Civil Rights Act of 1866. So Congress, before they pass the 14th Amendment, had already passed the Civil Rights Act, had to pass it over the president's veto. Andrew Johnson had vetoed it. And that law had set a definition for citizenship based on birthright citizenship. So the 14th Amendment is right off the bat going to establish this definition. And then it's going to confer certain rights on those new citizens. So it tells us who a citizen is. Then it tells us what kind of rights they have and what the effect on state power is. So if you're a citizen, we find that no state can make or enforce a law that abridges the privileges or immunities of citizens of the United States. So if you have a privilege or immunity as one of those citizens, and we find that those citizens include everyone born on American soil, which should be every person held in slavery in the United States at that point, because the international slave trade had been illegal since 1808. That gives us a serious limitation on states, telling us that states can't violate any of the privileges or immunities of these U.S. citizens. And so that's a fairly important provision. It also importantly puts things in terms of limits on states. No state shall do these things. We're also told that no state can deprive a person of life, liberty, or property without due process of law, and no state can deny to a person the equal protection of the laws without any person in its jurisdiction the equal protection of the laws. And Congress gets power to enforce those too. Now, the fact that it took the form of prohibitions on states was really quite important because it wasn't the only way that Congress could have done this. In fact, the first proposal, the sort of first draft of the 14th Amendment that comes from John Bingham, he's a member from Ohio that's going to shape the 14th Amendment in a fundamental way. His first effort to make a proposal here is actually a provision that says, the Congress shall have power to make all laws necessary and proper to secure to citizens of each state all privileges and immunities of citizens in the several states, and to all persons in the several states equal protection of life, liberty, and property. So listeners will hear a lot of the same words, right? You hear life, liberty, and property, you hear equal protection, you hear privileges and immunities, you hear citizens of the United States. Sounds like a lot of the same stuff, with one really important difference. And that is the original proposal proposes to give Congress power to make laws to do this. And so imagine if this language was in the Constitution and Congress couldn't pass a bill, right? Congress passed a civil rights bill, which they did in 1866. And let's say a future Congress repeals it. What then? Or would it furnish any protection? What would the 14th Amendment do? And the answer is that would just all rest on Congress having the political will to do something about it. The 14th Amendment we actually got by setting a definition of citizenship in the Constitution and then saying states shall not violate certain rights actually severs the connection from like dependence on legislative action and instead puts these limits in the Constitution so that even if Congress fails to act at that point, or maybe Congress winds up repealing its enactments, you still have these limits that courts could come along and enforce. This was actually a point that people in the debate made. They said, what if Democrats get control of Congress in a few years? What are we going to do then when they repeal all this stuff? And the argument was, well, if we put the limits in the Constitution, then future courts or future legislature can come along and enforce those adequately, even if we fail in the short term to do it. So that was a really, really important shift and really did change our constitutional order in a substantial way.
And I think you bring up a good point in terms of when and how it was passed, right? It was passed before welcoming the Southern congressmen back into the fold, and they did it and they framed it in a way that made it that much more difficult to try to carve some of this back, which again is very reflective of this moment of, we understand that we're extending and overturning the 3/5 compromise, but we also want to put in some safeguards to ensure that these newly emancipated Black Americans can exercise at least some modicum of political will.
That's right. And, if getting rid of the 3/5 compromise is great, as long as it results as well in an elevation of the political power of those folks who had been disenfranchised. I mean, the 3/5 of enslaved persons who had been counted in the census before the abolition of slavery, they didn't have any real political power, right? They just added to the state's political power. But the exercise of that power, that is how those votes were cast in Congress and so forth, was determined by the free people of the state, not by those disenfranchised persons. So if you get rid of the 3/5 compromise, great, as long as that results in an elevated political power, which is why certain provisions of the 14th Amendment are really important for trying to prevent those states from keeping those formerly enslaved persons disenfranchised. And also the 15th Amendment, which is going to, a couple of years later, confer a right to vote on, or at least prohibit states from abridging the right to vote on the basis of race, to try to ensure that people of color in the states, many of whom had been formerly enslaved, could actually exercise political influence. And so no big deal, as long as, the fact that South Carolina has more votes in Congress is fine, as long as all South Carolinians actually get to choose their members of Congress. And so those come as a package, which is really important for people to see this interrelation of the 13th, 14th, and 15th Amendments. Now, the 15th Amendment is really easy to explain in that respect, right? Secure voting rights for everyone without respect to race or previous condition of servitude. The other provisions of the 14th Amendment that most people had not heard of, at least until last year. For the first time, we actually had something other than sections 1 and 5 of the 14th Amendment that American citizens in general were talking about. And that was when Section 3 of the 14th Amendment became such a live issue, when the state of Colorado actually did, and other states were considering, disqualifying Donald Trump and other people who had had a connection to the January 6th riots at the Capitol from federal office holding, and keep them off the ballot on the grounds that they were made ineligible to hold office by Section 3 of the 14th Amendment. And that was because Section 3 was aimed at making sure that former Confederate officers, basically former Confederate politicians and elites who had participated in the Civil War and in that rebellion, could not turn around and show up in Congress and gain seats in the government, maybe even become president or something, and sort of undo the whole thing. And so Section 3 was supposed to prevent that. And it was an interesting thing because it's clearly aimed at, and you do have to imagine the 39th Congress is sitting there having refused to seat a whole passel of Southern representatives. And really part of it is, eventually we are going to have to let representatives from Tennessee, which is going to be the first actually in 1866 to get seats, South Carolina, Virginia, and the rest, are going to have seats in Congress. We can't disenfranchise them permanently. Like, you can't have like this Hunger Games scenario where we have some sort of, part of the country that never gets political power again. You can imagine how that ends whenever societies try to settle things that way. But how do we ensure that the people who were really responsible for this, the people who made decisions, who were in charge, don't remain in power? And that's what the ineligibility provision of Section 3 is about. It's there to try to render ineligible anybody who has previously sworn an oath to uphold and defend the Constitution. And that would have been anybody who had been in a state legislature, state executive office, judicial office, or of course any federal office, and then engaged in insurrection or rebellion. So you could actually put this in shorthand as oath breakers can't serve in the government anymore. So that was supposed to be part of the solution. It was coupled with another that was supposed to disenfranchise states in Congress, reduce their representation in Congress to the extent they disenfranchised any of their male citizens, 21 years of age or older. So if a state prevented any male within the state from voting who was 21 years of age or older, you could count up those people, and whatever percentage of the population that was, the male voting population, you'd lose your seats in Congress in proportion. A replacement for the 3/5 compromise.
Yeah.
But instead of reducing your population for enslavement, it reduces your influence in Congress on account of disenfranchising people. Yeah. So that was supposed to be a sort of short-term solution. And then the 15th Amendment is going to be the permanent solution to confer voting rights on those folks.
Yeah, and you talked about kind of the historic implications or the historic idea behind Section 3, otherwise known as the Insurrection Clause, if people are reading it in today's papers. So we get a sense of what it was intended to do originally. What barriers exist to using it in our current political moment?
Yeah, this was an interesting debate. When Colorado tried to keep Donald Trump off the ballot, a number of interesting objections came up, and they weren't just all from supporters of Donald Trump. There were actually a fair number of legal academics and historians and others who had no affinity for Trump, weren't his supporters politically, but said, look, it's just a bad idea to put in a democratic regime, you should lower barriers to office holding, not raise them. Basically, the argument was, if people want someone to represent them, it's essentially undemocratic to take away from them, without some very good reason, the ability to choose that person as their representative. That could be weaponized by people to disenfranchise certain groups and so forth, or to interfere with the democratic process. So there was a small d democratic, not Democratic Party, right, but a concern with majority rule, majoritarian government. Said this kind of limitation on the electorate is kind of inappropriate. There was another debate about, who got to enforce this. Is it appropriate? Because the text is written, and I'll lay out there my sort of cards. If you read the text as written, it just says, it basically adds to the list of qualifications to be president that you've never taken an oath to uphold the Constitution and then engaged in rebellion or insurrection or given aid and comfort to people who are doing so. And you could kind of add that to the list. So for members of the Senate, you have to be 30 years old. You have to have been a citizen for a number of years. You have to be actually resident in the state that you represent. And you have to have never broken your oath to support and defend the Constitution by engaging in insurrection. So it's sort of, if it's added to that list, the important conclusion was, well, then anybody who can usually enforce the qualifications for office could also enforce this Section 3 oathbreaker disqualification. So if you can keep somebody off the ballot because they're not old enough to be president, they're only, 34, not 35, then you can also keep them off the ballot because they engaged in insurrection or rebellion after swearing an oath. That became controversial because that's actually a quite long list of people. In any given state, states, this reminded Americans, we all learned this basic civics lesson about our federal system, that the federal government does not run elections in our country. There is no national election system of any kind. Congress has certain rules. We have constitutional amendments that tell states what kind of qualifications they can use to vote. But ultimately, Elections are carried out under the supervision and at the direction of states and local governments. So the people who decide who shows up on a ballot, in fact, even the people who decide whether there's going to be a presidential election at all in the state, because of course a fair number of states in our history in an early republic didn't have presidential elections. They actually just had the legislature chose electors. And there's nothing to keep them from doing that. The Constitution doesn't establish presidential elections. It establishes an electoral college and lets states decide how to pick the people who represent the state in the electoral college. So it's states that make those decisions. Well, that means that it's inevitably some state officer who decides, yes, you can be on the ballot because you are old enough and a resident and meet all the other qualifications to be a member of Congress. Or yes, you can be on the ballot for president because you're the candidate identified by a political party. This is actually a requirement. You get on a ballot in a state. State has to allow you onto the ballot, typically as the candidate of a party, and you meet all the other stuff. So that could be your local supervisor of elections, the Secretary of State, who knows? And so that kind of alarmed a lot of folks, right? They said, wow, okay, well, if you can just keep, Donald Trump off the ballot in Colorado, then, Texas can keep Biden off the ballot down there. And, we'll just have tit for tat, different states just taking the political opposition off the ballot, just pick the most promising person and then say they did something to disqualify themselves at some point. Whether that was a reasonable fear, whether that should really alarm us or not, I think is a question. It is in fact the case that, states could weaponize all kinds of requirements, the citizenship requirement. Of course, people could come up with specious grounds for keeping somebody off the ballot on the grounds that they're not a citizen. Think of the birther thing with Obama and so forth. That doesn't mean that states stop enforcing the qualification that you've got to be a U.S. citizen. I mean, if somebody shows up and just clearly doesn't meet the standard, surely the folks who are responsible for sticking names on the ballot can make those decisions. So, yeah, Section 3 wreaked a lot of havoc in the 2024 election cycle. And partly it's because we have this disqualification. It's fairly unique. We don't have typically qualifications for office are very easy to establish. They're numbers, right? You either pass the standard or you don't. You've lived here long enough or not. You are a citizen or you're not. You are a certain age or you're not. It's easy to imagine situations where that can be contestable, but that's not normal. A standard like, did you engage in or give aid and comfort to people who engaged in insurrection or rebellion? That's not a number. It's not an easily applied criterion in a lot of cases. So some folks thought that Congress was unwise by making this a general disqualification rather than just confining it to the Civil War, which they could have done. They could have made it retrospective. Any person before this date who's done this is disqualified, and could have just confined it to that moment. But instead, they put a general disqualification in the Constitution that would apply, like other constitutional provisions until you get rid of them, amend the Constitution. And that's sort of, I guess you could say, come back to bite us. Depends on whether you think it's wise to use it or not.
Well, I think a longer conversation than what we have time for today, but it gives me, I'm questioning now, how does this tie in with the impeachment process? Because if somebody's impeached, that usually prevents them from gaining elected office. And so there's a question of, if you are impeached or if you've committed significant high crimes and misdemeanors enough to warrant an impeachment, then was the insurrection clause perhaps needed, or did they just see it in that moment? You have my mind running.
Yeah, there were folks in the midst of the debate, a number of legal scholars who understood the language of Section 3 not to apply to the president and vice president, because it does mention officers of the United States, members of Congress. It doesn't mention the president specifically. And there were certain folks who argued, and one way or the other, you could go look at the arguments on it, that, the president and vice president were left off the list in part because they thought, well, there's so many barriers to becoming president, and that's a national decision. A local community in one state can make you a senator or representative. It does take the whole country to make you president. So erecting barriers to becoming president that are based on sectional conflicts is not very sensible because, well, the whole country makes the decision. It does make sense to make sure Virginia can't send a secessionist to Congress. Does it make the same sense to say that the whole country can't engage in an electoral process that results in some previous secessionist becoming president? The whole country wants them. So that was one approach, and there are some technicalities with the language that read this in a very sophisticated way and come to the conclusion that the president, if you want to disqualify a president or a vice president, what you do is you impeach them, and then you disqualify them from future office holding, which I think is probably what you have in mind, is that the impeachment provision is not just removal from office, but also disqualification from all future office holding, which was another backup argument of the folks who said, look, calm down. If we really thought it was this dangerous to have Donald Trump become president, Congress had an opportunity to impeach him, account of the January 6th stuff, and could have, in doing so, disqualified him from all future office holding. And that's really the appropriate process. It's the kind of political process we'd use to do that, not this sort of long dormant, inherited, constitutional provision that was shaped for a civil war, not for, however you want to cut it, riot, insurrectionist, we use different words to sort of load the dice on that, but no one could seriously argue that it's the kind of scope or cost or stakes that's involved in secession and civil war. And so, a lot of folks said, look, the right place to put this is the impeachment clause.
Yeah.
That's the political process that the Constitution sets up to handle this sort of thing.
And that is a good segue to move into a project that you oversee. So you are currently help oversee the Quill Project. Can you share what it is and how it started?
Oh, I'd love to. The Quill Project is aimed at recovering and making available to people the materials of our tradition of constitutional self-government. Americans engage in self-government first and foremost by making constitutions. And, a perceptive listener might think, wait a minute, we don't make constitutional language that often. We wrote our Constitution 230 years ago, and we've only amended it periodically since. But in fact, Americans have written about 235 constitutions. Our state constitutional tradition is robust and thick. Most states have had numerous constitutional texts that they've revised on a much more regular basis than the federal government does. So we as Americans do engage in constitution making and constitutional revision, or we could just put it constitutional self-government an awful lot. But it's not particularly easy to access the records of those things. You've got to be a pretty erudite person inclined to walk into, some state archive somewhere and dig through dusty boxes and records. Or at least be willing to get multi-volume sets of records off the shelf and sort of pore over them for months at the time to really understand what's going on in a state constitutional convention, or even our own federal constitutional convention. The work of the framers created that language, or the work of the Congresses. We've been talking about the 39th Congress. I mean, we've talked about the situation, the sort of conditions for the 39th Congress. We didn't dig into the whole nuts and bolts of how the Committee on Reconstruction actually went about framing the language. And I've mentioned there was a first draft, and then we had the final language. A lot of things happen in between. So the question is, how do you make those kinds of complex deliberative processes that produce constitutions or produce laws like the Civil Rights Act or constitutional amendments available both to ordinary citizens and to the people who teach about, do research on, the judges who decide cases on, or lawyers who litigate questions about what our constitutions mean and how we got them, or just want to know more about how we have done this in the past. In the past, that's been a difficult thing. The Quill Project seeks to remedy that, both by digitizing records that surround those kinds of processes, but also by making them accessible by visualizing them, right? Taking these hundreds, sometimes thousands of pages of deliberations, all these motions. There's a lot of parliamentary language. When people say, you're going to be on the town council, and it's sort of who's going to be the parliamentarian, or, whatever in the meeting. Like somebody's got to enforce the rules. And so there's a lot of technical language and people proposing things and rejecting things and amending things. So how can the ordinary person or even the ordinary state judge get hold of these things and make sense of them? So the Quill Project provides a way of modeling those. We can sort of visualize. You can take a text, a deliberation, and sort of see where, if I want to know where did the citizenship clause in the 14th Amendment first get introduced in that deliberation. You could go into the Quill model of the deliberation on the 14th Amendment, which we have. We modeled the 13th, 14th, 15th Amendments, as well as the primary civil rights legislation. You could go into the Quill Project's model of the 14th Amendment, find that text, and then find the point at which that language is introduced, the ways in which it changed over time, the people who are arguing for and against it. So it really makes accessible to people this sort of thing by creating these models and by putting the digital resources within the reach of the ordinary person and not behind a paywall.
Yeah.
We've done all this work. It's done in collaboration with a colleague at Pembroke College, Oxford. The Quill Project itself is housed there. And Utah Valley University, through the Center for Constitutional Studies here, has worked with them on a host of projects, which are not the only ones. They actually have projects on the Indian Constitution, the Good Friday Agreement in Northern Ireland, the Australian Constitution. So it's really an adaptable platform. It's an online platform that makes these things accessible to folks.
And in addition to making it generally accessible through digitization, how do you see the Quill Project kind of contributing to broader conversations about civic education today?
Well, I think two things. One is that it puts a lot of those records within reach of public debate in a way that they're ordinarily not. You think about when we're having this debate over the citizenship clause, birthright citizenship right now, it can be difficult to find a source for all the various records and debates and all that sort of thing. They're sort of stretched all over the place. But you could go to our collection and find all the relevant primary source documents that you need available to you. Something that we've done is also take sort of pieces of these deliberations and make lessons out of them. So we do a lot of equipping. We work with about 500 school teachers a year here in Utah, just on the issues of constitutional literacy and better equipping them to teach social studies and U.S. history and our constitutional tradition generally. But we've successfully taken sort of episodes from some of these deliberations, whether it's over the Utah State Constitution or the deliberations of the First Congress on the First Amendment, to give students a peek into that and shape some usable resources for the classroom where they can encounter those deliberations. I think the bigger picture thing I would say about that is Americans have traditionally engaged in this work of writing constitutions, and we've typically used constitutional conventions. That's the normal process for writing a constitution in American politics. And that's quite important because it's when we hold a constitutional convention in a state or at the federal level, we're putting together a group of representatives who have to sit down and look each other in the eye and decide how to settle the various big picture debates and the sort of small conflicts over the numbers and over influence. Those are decisions that have to be made. And we've become much more accustomed to a process where when we revise our constitutions, we tend to have a group of people, a special interest or some motivated group, often well-motivated and well-meaning group, crafts language that they then get in front of a legislature, and the legislature gets in front of the public, and we all sort of go to the polls and we read the language, or in many cases read the summary of the language on the ballot and vote, yes, I want to add that to the Constitution or not.
Yeah.
And the process that produced that language quite often is not really the kind of deliberative process that a constitutional convention engages in, where representatives of the whole public have to get in a room with each other for some period of time, look each other in the eye and come up with something they can agree on. That's a much different deliberative process than sort of crafting the language behind closed doors and then getting it on a ballot, whether it's with signatures or state legislative process. So I think we've lost a little bit of that constitutional technology of how to get together and deliberate on constitutional language. And so I think by resurrecting these, sort of in many cases long lost or, deeply buried records of these constitution making processes, I think making accessible to Americans and reminding Americans what a robust tradition we have of this. A state has not had a constitutional convention since the 1980s.
Mm.
This is the longest period. It was typical in a given decade for a few states to do this in American history. I mean, the norm was we had seasons of constitution making at any given time. The likelihood was some state was undergoing major processes of constitutional revision. And that meant you had alive at any given time a substantial number of Americans who had participated in constitutional conventions. In fact, when other countries write constitutions or did write constitutions in the 20th century, especially after World War II, quite often lawyers and representatives and people who had worked in state constitutional conventions would be enlisted as consultants and things to sort of come over and help us design this thing or help us, how does this process work? And we've reached a point now where we're 40 years out. I mean, we don't have anyone, there are very few people living who have participated in an American Constitutional Convention at any level. And that represents a kind of loss in our collective memory, a loss of a kind of skill that's probably essential for really successfully doing constitutional self-government. So Quill in the big picture is aimed at sort of restoring an appreciation for just how important that is and maybe remind Americans how to do it.
Well, and the website is very robust. I spent a lot of time playing around and looking at everything. So anybody that's interested in any kind of constitutional history or governance, the Quill is a treasure trove of information.
I will say one thing we're doing right now. We are putting together a Quill model of the Declaration of Independence. So the deliberative process in the Second Continental Congress that wrote the Declaration, which was a much more complex process than people think. Thomas Jefferson did sit down and come up with a draft, but he was handed a lot of language beforehand that had been produced by others before that and had to deliberate with others in doing it. Congress made a lot of changes themselves. So we've actually been putting together a resource collection of all the primary source documents that we can get our hands on related to the making of the Declaration, which is a little different than people who are arguing over the Declaration after the fact. We have a lot of access to things about how we argue over it later, but how it was made is actually something, one of these areas where the ordinary citizen would normally have a little bit of trouble getting hold of the documentary record and seeing what the documents mean. So we're going to have some very exciting models of the Declaration up, where you can sort of go look at the language and see, well, where did that language come from? And where did that come from? And how did this change? So we're excited about that. That'll be the first versions of that will be launching over this summer.
Oh, lovely.
Around July 4th, 2025. And then we'll have a much bigger, grander launch in the middle of the year next year with some robust resources.
Nice. Something to look forward to. You also co-host a podcast, This Constitution. So can you share a little bit about your show and how you got started?
Oh, yeah. Well, I think, I mentioned that we engage with a lot of school teachers in the state. We engage with a lot of ordinary citizens. We really aspire not to be in an ivory tower in the Center for Constitutional Studies. We encourage our faculty and our scholars and employ a lot of people who are engaged in the community and getting out and contacting folks and communicating with students and teachers and citizens. And in the spirit of that, we thought we really need a podcast that is grounded in academic expertise, but really accessible to ordinary folks. I mean, something that, someone would listen to on their half-hour commute in the morning or while carrying the kids to soccer or what have you. And so it's really supposed to be a podcast for we the people about their foundational documents, their Constitution, their foundational laws, what they mean, how we've argued over them. So we did our first season on the powers and limits of the presidency last fall. We just completed recording and are in the midst of walking out episodes on checks and balances for our second season. I figured that seemed timely. And then we interspersed in there all these fun little special episodes. We just dropped an episode I recorded with a British historian on Lexington and Concord. Sat down and launched that on the anniversary of Lexington and Concord back in April. And we will have we're going to have a special Juneteenth episode that will drop on Abraham Lincoln and slavery, and a special July 4th episode on John Dickinson and his role in shaping the ideas and politics that gave us the American Revolution. So we like to drop these special episodes in too, so always encourage folks to go find those. But we're on all the major platforms, Spotify, Apple Podcasts, and all the rest. So I hope people find it accessible and fun. And my co-host, Savannah Eccles-Johnston, is a lot more fun than I am. And she's really the brains behind putting that together. And we've had a lot of fun, which actually she's been a colleague up the road at Salt Lake Community College. And she's actually going to be joining us here as the new program director for our master's degree in constitutional government, civics, and law, which is aimed at K-12 school teachers, an MA in these subjects that teachers can get while they're working full time by concentrating their coursework in the summers and a little bit of evening work. So Savannah's going to be not just my podcast co-host, but on the CCS team here at UVU starting this summer.
How exciting. And I've listened to several episodes now of this Constitution. It's been added to my rotation. I can't wait to catch up on everything that I've missed. And you're hitting the mark if you're looking for something accessible. It's very easy to follow. The conversations are always very engaging. And so I can't wait to see what you guys come up with next.
Well, thank you, Alicia. I'm not sure if you can I think you can usually finish our episodes in the course of drinking a single cup of coffee, but I don't know if we can quite make that promise. I do love civics and coffee. You've done a great job too of putting together a conversation for people where they can explore these things and get a better understanding of, where our traditions and history and ideas and come from.
Well, thank you for that. I appreciate that. And where should people go to learn more about you, the Quill Project, and your podcast?
Oh, well, it's all on our website, uvu.edu/CCS for Center for Constitutional Studies. We're also on all the major social media platforms. We have an Instagram account, Facebook, Twitter, LinkedIn, and on most of those we are at CCS UVU.
Okay.
Our handle on most of those platforms. So you can find us in any of those places. But for those who might be in Utah or who are interested in live stream events, we have an events page on our website that will have links to the live streams and information about where to go. We have all kinds of fun things. This fall, we'll have our Constitution Day conference every September, and we'll be spending that this year with some exciting events, including a lecture from Nathaniel Philbrick on George Washington's constitutional legacy. It's for the 250th anniversary of his becoming commander-in-chief of the American Armed Forces. So we'll spend a little bit of time thinking about that with some great historians and legal scholars.
And as I let you go, is there anything we haven't covered that you think listeners should know when thinking about Reconstruction through a legal or a constitutional lens?
Yeah, you know what? Here's a thought to leave people with. We started out by asking, is the 13th and 14th Amendment a second founding? And part of the case for that is that it did change quite substantially the relationship between the federal government and the people of the United States. And you could think of it this way. I'm going to steal this from Akil Reed Amar's book on the Bill of Rights, which was written way back in the 90s. It's a good book. Amar, who's at Yale, he points out that when the Bill of Rights was passed in 1791, it put limits on the federal government. And in enforcing those limits, it often relied on local bodies, the jury trial. So you had, Congress shall not, infringe the right of the people against unreasonable search and seizure. And the security against that was if a federal officer broke those rules, they could be sued in a state court and then or even in federal court. And if there was a question in court, it would be settled by a jury, and the jury came from the local community. So all the distrust was pointed at the federal government. And the people you thought were going to protect you were the members of your own community, right? And the 14th Amendment really represents a reversal of that situation, or at least an addition to it, we're still skeptical of the federal government. We still rely on local institutions to resist them. States, state attorneys general do a lot of the job of preventing the federal government from violating our rights. But the 14th Amendment puts in place the process in the other direction too. It sets up a set of robust limits on states that are then enforced by a distant federal authority. So now instead of, the federal government's the enemy, the local community is your friend, I think the 14th Amendment recognizes that sometimes it's the local community. If you're a vulnerable person or you're a minority in your community, and by that I don't just mean racial minority, I mean you're just a political minority who's being neglected by the political process in your own community in ways that violate your federal rights, you can enlist the federal government to come in and protect you from that community, to enforce those rights in that way. So that's really the same way that the founding generations looking at the federal government with skepticism, the 14th Amendment looks at state and local governments with skepticism. And that's a very important change in American politics, that we now have that kind of mechanism. It's also, incidentally, I think, when I say the 14th Amendment's an elaboration on the Constitution or a fulfillment of it in some ways, I think that's because, for example, just to take Madison as an example, everybody's favorite example of founding principles, Madison doesn't win on everything. He's not right on everything, but man, he does see far in many respects. And people will remember, if they've read Federalist 10, or if they've read many of the things that Madison had to say around the framing of the Constitution, he too was very skeptical of states. He actually argued for a robust and powerful federal government because he actually said small republics, while they've got a lot of benefits, leave minorities unprotected. The tyranny of the majority is the biggest problem in the smallest communities. Yeah. And so you actually needed, he said, an extended republic where things had to proceed more on the basis of consensus. It's really hard to get 55% of the whole country to agree to do something. And so he pointed out a long time ago that in some cases, folks who find themselves outside the majority may need to shelter in federal power. He foresaw that in the Constitutional Convention and the first Congress and the ratification debates. And I think the 14th Amendment is kind of following through on that observation. Not in all respects. We still have a federal system. The federal government's still not, the principal government with respect to many of the things that impact our daily lives. But the relationship has changed in that respect, at least, that we do rely on them to protect our rights to a much greater extent than we did at the founding.
And I think with that is great closing sentiments. Thank you so much. To the listeners out there, I highly recommend adding this Constitution to your podcast playlist. Each episode is an illuminating lesson in civics and history, and it's one of my new favorites shows on my rotation. Also, please go check out the Quill Project. It is a historian's dream, all of the wonderful documents and all of the context provided. So thank you again, Matthew.
Thank you, Alicia. It's been a lot of fun.
Thank you again to Dr. Brogdon for sharing his insight with me. And be sure to check out the Quill Project and his podcast, This Constitution. The podcast is an incredible resource to better understanding our constitutional history and provides a wonderful civics education. You can listen to This Constitution wherever you listen to Civics and Coffee. Thanks, peeps. I'll see you next week.
Thanks for tuning in, and I hope you enjoyed this episode of Civics and Coffee. If you want to hear more small snippets from American history, be sure to subscribe wherever you get your podcasts. Thanks for joining me, and I look forward to our next cup of coffee together.